Welcome back. The Constitutional Court has heard arguments on whether the South African Human Rights Commission's recommendations carry the same legal weight as the Public Protector's Office. The Commission is appealing a Supreme Court of Appeal ruling, which last year found its directives aren't binding in a matter which centered around a dispute from water on a farm in Mpumalanga. The Commission spokesperson, Wisani Baloyi, joins us for more on this. Wisani, a very good evening to you. And I think I'd like us to start this conversation by just rehashing the crucial role of Chapter 9 institutions like yourselves.
Good evening to you, Masa, and good evening to your viewers. Indeed, Chapter 9 institutions play a critical role within the Constitution in South Africa. We ensure that those with human rights violation come to us, we promote human rights, and we also ensure that we monitor the observance of human rights. And if you look into this role, we get a number of complainants that come to us to lodge complaint at the Human Rights Commission to ensure that whenever there are human rights violations, those rights are realized. And as such, we release reports with findings. Just to give your viewers statistical information, in the past financial year, we finalized over 6,000 complaints. These are the people who came to us, whether is it through walk-ins, is it through telephones or through our website to lodge complaint, and we finalize those, which means that people get to realize their rights, and we play a critical role of ensuring that we are the watchdog. Government has a duty to ensure that they deliver on services. Human Rights Commission and other Chapter 9 institutions have got a role to ensure that they play the watchdog role within the Constitution as envisaged.
But because of this SCA ruling, would you say, Mr. Baloyi, that you've become a watchdog without teeth?
Indeed, hence, when the matter started in Mpumalanga, when Mr. Boshoff didn't adhere to our recommendations, we took the matter to the High Court, with the High Court indicated that our findings are not binding, and we took the matter to the SCA because we believe that if we continue with that precedent, it means that everyone can just simply ignore the rulings of the commissions, and meaning that we'll release reports with findings and recommendations, and someone can just simply say, go to court because your findings are not binding. And hence, even when the Supreme Court of Appeal addressed the issue of hierarchy within Chapter 9s, which indicated that there's no hierarchy as opposed to what the High Court in Mpumalanga indicated, we did know that this will impact on our powers, but also on our day-to-day operation. Hence, as the Commission, we felt that it is critical to take this matter to the Constitutional Court. The Constitutional Court will be able to interpret on Section 184 of the Constitution, which says the Commission must take steps to ensure that there is realization of rights. So that is the critical matter for the Commission to say, what does Section 184 mean, or the intention thereof, when we say we must take steps as an institution to ensure that there's realization of human rights. And we believe that the Constitutional Court is best placed to interpret on this and provide clarity on our functionality, but also the role of Chapter 9s within the Constitution, because you would recall that when we release reports that's addressing issues of water, when we release a report that's addressing issues of service delivery, when we release a report that's addressing issues of racism, for example, these are critical issues that affect people on a daily basis. And as an institution, we need to be clear and to provide clarity from the court on what is the meaning of taking steps to secure redress as envisaged in Section 184 of the Constitution. And as the Commission, we believe that this is a critical moment where the court will be able to give a clear direction of our mandate as an institution, which will make it simpler for us, but also for the public to know what the Constitution says, but also our mandate as envisaged in terms of the Constitution to ensure that people realize their rights and we continue to operate as envisaged.
You know, you also mentioned the thousands of cases that the South African Human Rights Commission works on, and obviously all of them being a matter of human rights. The case that was brought to the SCA, where it found that the Commission doesn't have legally binding powers, is a pivotal one. Now, I believe it's about a dispute over water on a farm. If you could remind us about that case that brought the South African Human Rights Commission to the Supreme Court of Appeal to begin with, and not having the consequences of not having that legally binding power when it comes to cases such as that one.
Indeed, you are correct. It addresses the issue of the right to water, a critical right because it affects the right to health. People need water to survive. This is about people who are living in a farm in Mpumalanga who came to the commission and indicated that the farm owner turned back on the arrangement that they had on them accessing water, and they came to the commission. The commission indeed, in its finding, indicated that not providing water to the community within the farming community in this instance is a violation of human rights, because in terms of ESTA, those people were supposed to be receiving water as per agreement. And the commission then directed that the farm owner provide water, and they should have discussion on how they should make arrangement on this access to water. And the farm owner didn't accede to the commission and took the matter to court. And you are correct, Masa, to say we deal with over 6,000 complaints. Imagine the practicality of taking each and every matter that we deal with to court, and how long the court will take to finalize or to agree with our findings to say they are binding on each and every matter. For us, this we interpret is as a delayed justice, because it means that we are going to have an overburden on the courts to be able to take each and every matter to court. And as the commission, we've assisted a lot of community members with dealing with finalization of cases and ensuring that people realize various rights that have been violated. And also, when we say 6,000 complaints, it's not 6,000 individual complaints all in all. We also have systemic complaints which deal with rights realization within a bigger community, whether it's the province, and you will realize that when you then actualize the 6,000 complaints, it's actually more than 6,000 complaints. And for us, as the commission, we say our role as created by the Constitution, we believe that is that of ensuring that people realize these rights quicker, unlike taking each and every matter to a court, because we also get referrals from other NGOs because they are of the same view that the commission has got binding powers, which assists us to be able to ensure that people realize their rights. We've just celebrated 30 years of our existence. We have dealt with a number of human rights issues within the country. And this case, like as it was argued in court, to say we had not dealt with people who would say we are challenging the constitutionality of Section 184 and the interpretation that we have. And it provides us then with a clear view to say 30 years later and starting a new 30-year journey, let the court clarify this matter, which at the end of the day, it will also help to clarify to the country at large, and also signal the importance of Chapter 9 institution within the Constitution to say, when we say we play a role of ensuring that we play the role of the watchdog, what is the responsibilities? Because it's not only about individual. We also issue reports that addresses service delivery, which comes from government, whichever sphere of government. And we need to ensure that the institutions such as the Human Rights Commission are respected, and our recommendations are implemented as envisaged in terms of our mandate, but also in terms of Human Rights Act, and also drawing from the Constitution, which gives us the broader mandate.
And as you're saying, Mr. Baloyi, 30 years later, we'll get clarity from the courts about this. Would you say currently there's a legal grey area here? I mean, which law applies? The Constitution does empower the Commission to secure appropriate redress where human rights have been violated. But how do you ensure this redress without it being legally binding?
Indeed, you've put it so well in that the Commission throughout the years, when we do complaints and procedure, but also in terms of our own Human Rights Act, we have always said that our meaning of securing redress, it means we investigate complaints, we issue findings, report with findings and recommendations. And recommendations are sent to the complainants and the respondents with time frames in terms of the respondents on when they should ensure that they implement our recommendations. Usually it's around 60 days. And it's critical then to say, the good thing is that for the past 30 years, many of our recommendations have been sent. No one has challenged the constitutionality of Section 184 and our interpretation. And now it also gives us an opportunity to say, how do we ensure that this human rights realization? Because you would recall that you would have many reports that we've issued on a number of human rights issues, whether it's the right to water, the right to housing, socio-economic rights in general, and the many other rights that affect people on a daily basis. And without clarity on the powers that the Commission has, it becomes difficult now to say we can issue a report with findings. We issued a report on service delivery in the Northwest. Someone can just decide to say we are not agreeing with the Commission until the Commission takes this to court and make it a binding decision. But also look into how long will that impact on people who are dependent on various spheres of government, in this instance, to be able to provide services, but also even to individuals. If you've got people within the farming community whom, in this instance, they are not able to get access to water, and the farm owner then would say, whatever the Commission says, it must take the matter to court. How long would it take for the Commission to get the matter to be made a binding decision? But also the impact of that financially in terms of the practicality and the implementation. So it's a number of issues which requires clarity. But the good thing is that once clarity is sought, it will provide a way forward on how do we ensure that then the many reports that we've issued as the Commission, some have been implemented, some have not been implemented. What then it means if the court indeed agrees with us that our powers are binding on the responsibility of people who have received these complaints to ensure that they respond within the time frame, but ensuring that once they respond, it affects the people who are supposed to be receiving services at the end of the day. And we believe that the Commission has a crucial role to ensure that government implement services, discharges their mandate, and ours is to ensure that we just monitor and ensure that people realize their rights. We've got communities who still don't have access to water as we speak, and many other rights that are critical in terms of the Constitution. So we believe that it is good that the matter went as far as the Constitutional Court. Once the Constitutional Court has interpreted on the mandate of the Commission and the meaning of Section 184, it will be clear for everyone going forward to say what is the envisaged intention around Chapter 9 institution, the Human Rights Commission in particular, in making sure that when we spend finances doing investigations and resources, what is the intention to ensure that at the end of the day, we don't conduct investigations which at the end of the day we need to go to court again to ensure that they are made to be binding. So we believe that it is critical for the court to clarify. It will also be critical for us to be able to know how do we function as the Commission to ensure that those who come to us, the magnitude of people, whenever their rights are violated, how do you ensure that we protect them? Thank you.
That clarity is needed indeed. Wisani Baloyi, thank you so much for your time.